result of the additional capacity of the water supply infrastructure resulting from Phase 1 works or Phase 2 works as such capacity is increased by or with the approval of the developer from time to time in accordance with this agreement and the lease. The developer's sole recourse and remedy will be under one or more latecomer agreements as otherwise agreed to in writing between you and the developer. This agreement is intended by the parties to govern the design and construction of Phase 1 works and Phase 2 works only. Nothing in this agreement shall be interpreted as an agreement on the developer's part to be responsible for the design and construction of any water infrastructure other than that expressly contemplated under this agreement. Notwithstanding the foregoing, the developer acknowledges that it remains solely responsible to provide all water infrastructure development required under the water service bylaw. Subject to section 8.12 thereof, if by December 31st, 2014, the Phase 1 works are not completed and the water treatment facility is not operational at the temporary water facility site, then in the absence of a written agreement between the parties to amend the date hereinafter provided, this agreement shall automatically terminate and no further force or effect. Water infrastructure Phase 1 works. The developer shall design and construct, or design and construct the developer's sole cost and expense of Phase 1 works in accordance with this agreement of the water services bylaw, without limiting the generality of the foregoing. The developer shall A. Make available to UBID pursuant to the lease the temporary water facility site and the water treatment facility, while it is located at the temporary water facility site, both of which shall be owned by the developer for as long as the lease is in effect.
Owned by the developer.
Granted in favor of UBID any statutory right-of-ways over the lands required by UBID to secure rights for the operation and maintenance of the water supply infrastructure or water distribution infrastructure are located on the lands upon completion of the Phase 1 works. Substantially in the form of statutory right-of-way attached here to as Schedule E, with such reasonable amendments thereto as may be agreed upon by the parties to accommodate specific characteristics of the portion of the land against which statutory rights-of-way is to be registered, including without limitation provision for specific right-of-ways of the areas to be surveyed, rather than having statutory right-of-way registered under a blank chart. I hope we all understand all this, because this is what we are asking the board members here today to approve. Engage all required consultants, contractors, and trades to design and construct the Phase 1 works. Provide to UBID for UBID's approval copies of all studies, reports, cost estimates. Has that been done? I don't know, Kevin, has that been done? No. So how can we approve this agreement? Provide to UBID for UBID's approval copies of all studies, reports, cost estimates, including future operational and maintenance cost estimates, designs, and specifications obtained or commissioned by the developer from accredited third-party professionals for Phase 1 works, as required by UBID, and in accordance with the water servicing bylaw, to substantiate the sufficiency of the Phase 1 works and to identify what upgrades, if any, are required to the water supply infrastructure and the water distribution infrastructure to satisfy the requirements of the development as it is developed by the developer. Not construct any of Phase 1 works until UBID has, in its sole discretion, approved the studies, reports, cost estimates, designs, and specifications submitted by the developer in accordance with subsection 3.1 sub D. Cooperate with UBID to assist UBID in obtaining all third-party consents, permits, approvals, and operating certificates to complete the water supply infrastructure where required by others. Vancouver Island Health Authority and the Provincial Ministry of Health. I don't know where VHA stands on this. I'm new on the board. I've yet to hear from VHA, and I'm sure they will be talking to us. Upon completion of the Phase 1 works, submit to UBID such certification by third-party professionals that UBID requires to verify that the Phase 1 works have been constructed in accordance with design specifications. Comply with all applicable laws. It is the intention of the parties that the water treatment facility will not remain at the temporary water facility site permanently. UBID acknowledges the developer's intention to develop the temporary water facility site as soon as possible after the relocation of the water treatment facility from the temporary water facility site to the permanent water facility site. So we're going to do it once and then we're going to do it again. The developer shall design and construct, or cause to be designed and constructed at the developer's sole cost and expense, the Phase 2 works in accordance with this agreement and the water servicing bylaw, without limiting the generality of the foregoing. The developer shall grant in favor of UBID any statutory rights-of-way over lands required by UBID to secure rights over the water supply infrastructure or water distribution infrastructure that are considered as part of Phase 2 works, which are located on the land substantially in the form of statutory right-of-way attached hereto Schedule E, with such reasonable amendments thereto that as may be agreed upon by the parties to accommodate specific characteristics of the portion of the land against which statutory right-of-way is to be registered, including without limitation provisions for a specific right-of-way area to be surveyed rather than having statutory right-of-way registered against a blanket charge. Engage all required consultants, contractors, and trades to design and construct the water distribution infrastructure. Provide for UBID's approval copies of all studies and cost estimates, including future operational and maintenance cost estimates. Designs and specifications obtained or commissioned by the developer from accredited third-party professionals for the Phase 2 works as required by UBID and in accordance with the water servicing bylaw to substantiate the adequacy of the supply of water in Langley Lake for the planned capacity of the Phase 2 works. As such works are constructed and installed in stages, the sufficiency of the Phase 2 works and to identify what upgrades, if any, are required to the water supply infrastructure and water distribution infrastructure to satisfy the requirements of the development as it is developed by the developer. Not construct any of Phase 2 works until UBID has, in its sole discretion, approved the studies, reports, cost estimates, design, and specifications. Cooperate with UBID to assist in obtaining all third-party consents, permits, approvals, and operating certificates to complete the water distribution infrastructure, when required by, among others, Vancouver Island Health Authority, Provincial Ministry of Health. This is the Phase 2 works. Upon completion of Phase 2 works, submit to UBID such certification by third-party professionals that UBID requires to verify that the Phase 2 works have been constructed in accordance with design specifications approved by UBID under Section 4.1 sub E and comply with all applicable laws. The developer obligates to construct any portion of the water infrastructure developer in connection with a permanent facility site subject to UBID securing a long-term land tenure, which has now been done, pursuant to which the permanent facility can be constructed on the permanent facility site. Maintenance and warranty of water infrastructure. Subject to subsection 5.4, the developer will transfer to UBID the Phase 1 works following completion of construction thereof, or completion of construction of such stages thereof, and shall provide the warranty for the water infrastructure. When a third party is providing a warranty on behalf of the developer shall have no liability to UBID with respect to such warranty. The developer will transfer to UBID the Phase 2 works upon completion of construction thereof, or completion of construction of such stages thereof, and shall provide the warranty for the water infrastructure developer. When a third party providing a warranty on behalf of the developer shall have no liability. Subject to Section 5.4, upon the effective commencement date for the warranty of such portion of Phase 1 works or Phase 2 works as are completed at any particular time, the developer will transfer by a bill of sale the terms of which are to be to the satisfaction of UBID, acting reasonably for nominal consideration for such completed portions of the water infrastructure to UBID, free and clear of all liens, charges, and encumbrances. UBID shall own all of the water infrastructure under Phase 2 and shall become the owner of the water infrastructure or such portions thereof that are completed. Notwithstanding Sections 5.1 and 5.3 thereof, or anything else set out in this agreement, the developer will retain ownership of the water treatment facility at all times while it is situated at the temporary water facility site, and will have no obligation to transfer ownership of the water treatment facility pursuant to Section 5.2 and 5.3 until the water treatment facility is installed as part of Phase 2 works at the permanent water facility site. So Kensington will own the Trapberry site. Upon completion of Phase 1 works or Phase 2 works, or any stages or portions thereof, as completed by the developer or between UBID and the developer, UBID shall assume all responsibilities for staffing, operating, and maintaining the water infrastructure development, except to the extent of the warranty provided by the developer or a third party on behalf of the developer, and subject to the terms of the lease. The developer shall pay UBID to train one staff member to operate the water infrastructure, and if required by UBID, for the first 15 months after the initial delivery of the water infrastructure, the developer shall pay 50% of one full-time equivalent to operate the water infrastructure. For greater certainty, and this goes on and on for another... No, I'm not going to cut, because you're asking us to vote on something that we need to continue through. What I would suggest, though, if we want to really cut to the chase, is that the motion would be amended that the board would retain legal advice to instruct the board as to exactly what the water agreement means or does not mean. And in concert with that, Hugh McConnell would consult with the board to inform the board of what the agreement means or does not mean. Hugh McConnell is the consultant that was hired by the board to develop a new water infrastructure agreement. My biggest concern over the old water infrastructure agreement, it's not something you can just renew. We do need to have a new water agreement. There's no question about that. But to renew an old agreement that is fraught with many, many clauses that no one really totally understands and knows what the future ramifications will be for the taxpayer of this community is absolutely, it astounds me that the board would even consider doing that.
Okay.
Given that the number of people that we've seen on the petition that was presented today to join the CBRD, it's a substantial number of people. I'm not advocating that at this time, but I do think that the board is not informed well enough to make a decision on this at this time. And I do not think the old agreement is in concert with the MOU, which has already been approved by the board. The MOU is a framework for hammering out a new agreement. It's in place. It has been agreed to by the board. And the board needs to keep that in mind when we're proceeding with getting infrastructure in this community that we all want and need. So, you know, I'm prepared to go on reading as we go through this right to the end. That's what it's going to require. And I would hope at the end of that the mover of the motion would reconsider his motion to proceed at this time under this old agreement.
Can I comment on that?
Yes.
Well, first of all, thank you very much.
Sorry,
for your input. What?
I haven't finished yet, but go ahead, Mr. Chair.
Well, all right, finish.
I'd like to comment.
No, well,
Okay, go ahead.
Well,
perhaps Mr. Loxton.
no, Trustee Elliott has the floor. Please continue.
Perhaps Mr. Loxton would like to reconsider his motion.
So basically, you're trying to lock in this guy.
Out of order.
Hey, hold it.
Out of order.
No comment. Continue with your,
Okay, so for greater certainty, UBID's obligation to maintain the Phase 1 work shall not in any circumstance permit or authorize UBID to increase the capacity of the water treatment facility at any time without the approval of the developer. No works to increase the capacity of the water treatment facility shall be carried out unless the developer, at its sole discretion, consents to such works. And such work shall be exclusively carried out by or at the discretion of the developer. But such increase in capacity shall always remain subject to the requirements of the water distribution bylaw and the water servicing bylaw. Upon the developer transferring to UBID the Phase 1 works or the Phase 2 works or at any stage or portion thereof as completed, and UBID duly adopting a bylaw authorizing UBID to levy CECs in connection with the new capital cost burden on UBID of providing and improving water services to the land in respect of the water infrastructure, so transferred by the developer to UBID. The developer will pay UBID CECs, providing always the developer is entitled to set off, and UBID will recognize as a credit against any such CECs the sum of the developer's actual out-of-pocket costs and expenses incurred by the developer, not given to us for free, to design and construct the water infrastructure in accordance with Articles 2 and 3 thereof. UBID's right to enforce the developer's covenants in Section 5.2 and 5.4 hereto to transfer the water treatment facility UBID after the developer has completed the installation of the water treatment facility as part of Phase 2 works at the permanent water facility site shall have priority over any other charge, encumbrance, or security interest granted by the developer to a third party in respect of the water treatment facility, and the developer will cooperate with UBID to grant UBID a registrable interest in the water treatment facility in the personal property registry as permitted by the applicable legislation to better secure UBID's right to priority to any competing security interest of a third party. Ownership of the assets. In connection with the transfer of the water license to a third party, the transferee who has secured all required approvals to take a transfer of the water license or have a new water license issued. If the water license is being cancelled and replaced, the parties agree to cooperate with each other in the following. UBID transferring and assigning all of its rights, titles, and interests to, under the water supply infrastructure agreement to such a third party. B, transferee assuming all the obligations of UBID hereunder and covenanting in favor of the developer to abide by and fulfill all the obligations of UBID hereunder. C, the transferee recognizes all ancillary agreements made by the developer and UBID pursuant to this agreement, including, without limitation, all agreements made pursuant to Article 7 thereof. 6.2. Notwithstanding 6.1, in no circumstance will UBID voluntarily transfer the water license or otherwise transfer or convey the water supply infrastructure while the water treatment facility remains in the operation at the temporary water facility, as that's owned by the board. Upon the transfer of the water license and the transfer or conveyance of the water supply infrastructure to the transferee in accordance with Section 6.2, but without a concurrent transfer or conveyance of the water distribution infrastructure, UBID and the developer shall remain bound by the terms of this agreement as it relates only to the water distribution infrastructure. Upon the water treatment facility being relocated from the temporary water facility site to a permanent water facility site, lease shall automatically terminate and UBID shall decommission the water infrastructure on the temporary water facility site to the extent that such water infrastructure is not required to further service development or on the temporary water facility site, and restore the temporary water facility site to a natural state as to opposed to its condition at the commencement of the terms of the lease. In other words, UBID is responsible for decommissioning the existing site when the temporary site is transferred to the new site. If Union Bay incorporates, you have to ask the chair.
No, trustee
I don't
Elliott
think
has the chair.
a resolution to the point of order.
That's what we're getting to. He's expressing his point of order now.
If Union Bay incorporates as a municipality or UBID is otherwise dissolved, then prior to the effective date thereof, UBID will cooperate with the developer to ensure that the successor to UBID with respect to the supply and distribution of the water to the lands assumes all the obligations of UBID hereunder. Latecomer agreements and CEC recoveries. The Phase 1 work shall be subject to one or more latecomer agreements to the extent that the Phase 1 works are excessive, or extend service within the meaning of Section 7.4 and 7.2 of the Local Government Act, with the exception of the existing Union Bay residents as at the date of this agreement, plus up to an additional 10 new residents per year in Union Bay outside the lands of the cover. In connection with Phase 2 works, as it may be constructed in stages, the party anticipates the developer will have the benefit of one or more latecomer agreements. Notwithstanding the foregoing, the developer acknowledges that if either of both of the water supply infrastructure or the water distribution infrastructure is transferred in accordance with Article 6 thereof, the developer has not yet entered into all applicable latecomer agreements with UBID at the time of such transfer, then the form of latecomer agreements may change from that which is attached here to as Schedule D. The substance of the latecomer agreement as contemplated herein shall not be affected by any such transfer. All proven reasonable costs and expenses incurred by the developer in respect of the design and construction of Phase 1 works and Phase 2 works shall be eligible to be offset by the developer against CECs, whether levied by UBID or a transferee of the water infrastructure or any portion or component thereof, except to the extent that UBID and the developer entered into one or more latecomer agreements in respect thereof. UBID shall cooperate with the developer to ensure that any transferee of the water infrastructure supply or portion or component thereof, or the water distribution infrastructure or portion or component thereof, agree to recognize all latecomer agreements entered pursuant to this article and all credits and rights to offset set out in this article. Nothing contained or implied herein will prejudice or affect the rights and powers of UBID in the exercise of its function under any legislation, bylaws, orders, or regulations, all of which may be fully and effectively exercised in relationship to the lands as if this agreement has not been executed or delivered by the developer, and the obligations of the developer under this agreement shall be subject to such legislation, bylaws, orders, and regulations in force for all the time. Page 11. The covenants contained in this agreement shall ensure to the benefit of and be binding upon UBID and its successors and assigns and shall ensure to the benefit of shall ensure to the benefit of and be binding upon the developer and its successors and assigns. Every reference to UBID and the developer is determined to include their successors and assigns as the case may be. The developer and UBID shall do and cause to be done all things and execute and cause to be executed all documents which may be necessary to give proper effect to the intention of this agreement. UBID agrees that if UBID is notified of a proposed alteration of boundaries of UBID or incorporation of a new local government whose boundaries would include the lands, UBID will advise the minister responsible for the administration of the Local Government Act of this agreement and the intentions of the party. UBID agrees that the developer is not liable for a breach of this agreement occurring or discovered after the developer ceases to be the owners of the land and the water infrastructure. All notices to the developer and to UBID must be in writing personally and personally delivered or sent by prepaid registered mail or by facsimile or to the address below UBID's address, the developer's address. This agreement may be executed in two or more counterparts. Each counterpart, when executed and delivered, shall have the same force and effect as an original instrument, as if the parties had executed and delivered the same instrument. If any paragraph, section, subsection, paragraph, sentence, clause, or phrase in this agreement is for any reason held to be invalid by the decision of a court or competent jurisdiction, the invalid portion shall be severed, and the decision that is invalid shall not affect the validity of the remainder of this agreement. In other words, if a portion of this is found to be invalid for whatever reason, the rest of the agreement remains in place. This agreement and the obligations of the party hereunder shall be interpreted, construed, and enforced in accordance with the laws of the province of British Columbia, Canada. If a developer sells a portion of the lands, then this agreement shall be deemed to run with such portion of the lands, and the developer must obtain the written agreement from the transferee of such portion of the lands to assume all of the obligations of the developer hereunder. Time is of the essence of this agreement. If either of the party hereunto is prevented or delayed from undertaking or completing its respective obligations hereunto as a result of earthquake, flood, or other act of God, fire, explosion, or accident, however caused, act of any government authority, strike, lockout, inability to obtain or delay in obtaining labor, supplies, materials, or equipment, delay or failure by carriers or contractors, breakages, or other casualties, climatic conditions, or any other event of nature in so whatsoever beyond the reasonable control of the respective parties and the date to which this obligation is to be undertaken uncompleted will be extended for a period equivalent to such period of delay. When we get into all the legals and all the schedules, Schedule B's, which is basically a schedule of all the terms of what the land means, terms of this agreement. Is this all part of the water infrastructure agreement?
Yes.
Oh, yeah.
Well, that's the schedule. However, you made your point there, Trustee Elliott.
Okay, well, I'd like to conclude, I'm not going to
Okay.
continue reading from this, but I would really like to encourage Trustee Loxam to reconsider his motion. I believe a motion of that nature, when there are so many issues in this agreement that I don't think anybody sitting at this table really understand, is a motion that really needs to die at this point in time until there can be a proper meeting for all of us to fully understand the ramifications of this water agreement. We're not only talking about where our political points of view may be at this table, but we're also representing all the ratepayers of the improvement district. We are obligating, we're moving forward in a manner that could have far-reaching financial ramifications for all of the ratepayers that are in UBID, should it be found there is something in this agreement that commits us all to proceeding with this agreement without fully understanding all that.
Okay, thank you very much. Now, Trustee Fitton, you're up next. We're under discussion here. You have been engaged.
Well, my point on this is I believe that this contract is legal and binding. You know, and if so, you know, Jim has a point that it needs to be legally verified, and that's what we're asking for. That when we go forward to the lawyer, that he's going to look at this and say, yes, this is legally standing. If it is, then it's a liability and a risk to the ratepayers. Exactly going back to the Naramata point you guys made, where a developer sued a water district or an improvement district over false claims for water. But in this case, if he has a legal contract with us and the force majeure clause, which you just read, states he was held up on an environmental study, giving him time, I understand, till, and I shouldn't quote any dates because I would be, I haven't quite been educated to that point. But the force majeure clause allows his contract to be valid. People saying it's expired is a very dangerous thing to be doing. So that's my opinion on it, and that's why we need to move forward, give it to our lawyer, and have him decide what the right thing to do is.
Okay, thank you, Trustee Fitton. Trustee Loxam, we won't go there. Trustee Kelger, what would you
My understanding was that you were putting a motion forward to have this.
Trustee Loxam put a motion
Trustee
forward.
Loxam put forward a motion to have this water infrastructure agreement renewed, extended. I think that is.
Okay, well, go ahead.
So, well, I'm asking.
Well,
I'm
okay, the
clear
actual
now what
words
the
were
motion
that
is. Tell me.
he was asking our administrator to contact our legal counsel and have him enable the force majeure clause that exists in this contract.
Which would effectively renew the contract.
Yes.
Yeah, so I'm saying that is exceedingly dangerous, given that by Trustee Fitton's own words, we need to understand what the implications are legally and financially on UBID of this agreement taking effect, and we don't have that information yet.
Okay.
Trustee Elliott's point was, wait a minute, before we do that, we need to be informed as trustees on the implications, because we're acting on behalf of the landowners. So I am stunned that this motion has come forward, given how new we are, and I beg your pardon?
No, I'm not talking to you, I'm talking to this old man's club.
No comments from the audience, please. We'll get through this.
This is extreme, I don't know if you guys fully understand how incredibly important this, what's being discussed right now is.
Okay, please continue.
Well, now I've lost my train of thought, but essentially, I agree with Trustee Elliott's point of order that this is out of procedure for us to approve the motion as set out by Trustee Lawson